Welcome back to another edition of Between Two FARS. I'm Warneke Miller, here once again with Bob Tepfer and Michael Mark, talking about one of our favorite subjects, litigation in front of the ASBCA. Now, we want to give you an overview of what motion practice generally looks like in front of the ASBCA. So today we're going to be talking about Rule 7. What can you tell us about Rule 7, Bob?
Well, you see what it generally looks like in front of the board. And that's one of the things. You take a look at the first sentence in Rule 7. It says, the board may entertain and rule upon motions and defer ruling as appropriate. Okay, the emphasis as appropriate. You may go into a case and it may have a very rigid adherence to the federal rules. Alternatively, you may have a judge that views this as very relaxed. Let's just get to the point and address the issues, and the federal rules will not apply. The as appropriate tells you, if you think you got a motion, go ahead and file it. Don't worry about precedent or things that you've seen. If it's max of getting to the point, the judge will probably rule on it. I once had a case where the issue was a very sophisticated accounting issue. The opposing counsel was, to be nice about it, was making life miserable. And so to get to the point, rather than have a bunch of expert witnesses called to the stand and swear with regard to their interpretation, which I wasn't sure was the appropriate thing, I said to the judge, why don't you appoint a master who has a CPA, certified public accountant, and have that individual examine the facts and make a ruling based upon the evidence that we've put before them. Well, the judge had never heard of having a master, but he really liked the idea and proceeded to appoint a master. The case was turned over to them on that very focused issue, which made all the difference to the world in the world regarding equal access to justice. My point being that just because you can't find a lot of precedent on that issue doesn't mean you can't file a motion with regard to it. So make up your own motion. If it gets to the point of addressing issues in the case and put it in real nice, on the cover, you're probably going to have it be listened to by the judge and get a response from the opposition.
Yeah, remember the board, it was originally created as alternative dispute resolution mechanism. So their rules are sort of loose and the judges are all over the place with regard to how closely they want to adhere to those rules, because the rules are written in a way where, one judge should say, well, I'll rule on all of that just before we go to the hearing, or I'll rule on it after the hearing. So why are we doing this? So part of it is to convince the judge, as Bob said, to convince the judge, hey, judge, this is a smart thing to do. They haven't stated a case, or it's so complicated, everybody's going to be confused, and it'd be easier to get an expert to help us out. So there's a lot of fluidity with regard to the way you practice in front of the ASBCA as opposed to the way you would practice in front of a court. And you need to keep that in mind. It's also helpful to know who the judge is. Some of the judges have a reputation being very strict on the rules and others don't. And so if you know that in advance, you can begin to craft your strategy to kind of accord with the way we understand that judge thinks. And that can be very helpful to your case as well.
I think Michael's really right about that. You should know everything about your judge and take a look at other cases and other rulings, because that'll tell you whether or not they're going to be a strict issue of compliance with the federal rules, or whether or not the judge is just trying to get to the facts.
Mm-hmm.
Excellent. Thank you guys so much for your tips and pointers on motion practice in front of the ASBCA. Join us again next time, Between Two FARS.